Welcome to Studying Law Around the World. I'm Claudio Klaus. In each episode, I talk with lawyers, law students, and professors from different parts of the world to talk about legal education, careers, and what the profession looks like in real life. We talk about the hard parts, the surprises, and the decisions that shaped their paths. Whether you're planning to study abroad, thinking about working in another legal system, or just curious about how law works around the world, this podcast is for you.
Today, I'm interviewing Tom Macintosh Zheng. He's returning to the podcast for some new exciting updates. We first talked about Court Ready, I believe last year, and now we have some very interesting topics to be discussing in this episode. Thank you so much for making the time to be here, Tom.
Well, thank you very much for having me. It's always glad to be back.
Amazing. And to start our podcast, I always appreciate if you can just introduce yourself briefly for maybe listeners who are listening to this episode before our previous one, or who are kind of first coming to the podcast.
Yeah, absolutely. So my name is Tom Macintosh Zheng. I'm the co-founder of courtready.ca, where we build practical tools to help Canadians navigate the legal system. And from time to time, we conduct studies into access to justice issues in Canada. I used to be a commercial barrister in practicing in Toronto, and I'm also qualified as a solicitor in England and Wales.
Amazing, fantastic. And to kind of get right on the topic of our conversation today, talking a little bit about Court Ready and a little bit about, the whole world of technology, AI, and so forth. It was interesting that in our first conversation, we talked about how there were so many different tools that could be used in legal practice that actually didn't even need AI. They were simpler tools, but they just could really complement the practice. Ever since then, lots have happened. And everyone, from junior lawyers, self-represented litigants, and even members of the judiciary are learning about generative AI and maybe using it to some extent to save time, to save fees, and to get an understanding of different things. But there are some problems with that, right? So we did learn that there is made up citations, some kinds of hallucinations, and specifically the research you conducted found a great deal, I think over 200 made up citations that affected over 100 cases or 100 decisions. So I wanted to hear a little bit about that, about, your research, how that came about, and maybe even are those the result of AI that was used in the past and now AI is better and, doesn't hallucinate as much anymore? What's your view on all of that?
Right. So to start with, many of us know that when we use publicly available AI tools, sometimes the tool has a tendency to hallucinate. So what I mean by that is you ask it a question and it would provide the answer, and the answer sometimes is incorrect. That happens also in the field of law, right? So as an experiment myself, sometimes I would ask it to give me the answer to a legal question. Now, for simple ones, it has the tendency to get the answer correct. But say if you ask any of these tools that do not have access to a law database, what are the top 5 cases in Canada on a particular topic? When you ask that question and you get the answer, I've seen that it might give me cases that don't exist. It might give me cases that has a real name, but the substance of the case is completely different. Or it would give me quotes from a case, but then those quotes actually do not exist in that case itself. So then I ask myself the question, has this particular issue of AI hallucination impacting our courts and tribunals? Because we know that a lot of folks who may not have the means to afford a lawyer, or who may not be comfortable writing in legal English and French, turn to these AI tools to help them write and help them research. Plus, other than say a small disclaimer at the bottom of every tool, say, blah, blah, blah can make mistakes, the tools don't really prompt you that, hey, wait a second, these cases may not be real. So for someone without a legal background, when they see a confident case citation from one of these AI tools, they think that it is real. So as the context for why we did this research, and what was very surprising to me is that since 2024, there have been 36 court cases and tribunals where the court or the tribunal flagged that a party's submissions contain fictitious citations. 136 decisions. So that's where the court caught people submitting cases that don't exist. There are separately 18 other cases where the court warned a party about AI misuse. But looking at the 136, they are all over the country. They're in 45 courts and tribunals. And in total, there are at least 247 fictitious citations that were submitted across these 136 decisions. And the trend is accelerating. We had about 7 or 8 instances in 2024, 80 cases in 2025. And in the first quarter of 2026 alone, there were 50 cases. So naturally, the question is, these were the instances that were caught by the courts and tribunal. But that means statistically, and again, I am speculating here a little bit, there ought to be instances where these cases made into an actual decision unnoticed by everyone along the way. Now, we actually have seen the first instance of this being reported where a decision contained fictitious citations. There is a case out in Quebec. Obviously, we don't know who was ultimately responsible, but that was the first, at least reported case of a decision containing AI hallucinated citations that no one was able to stop before it was released.
Well, thank you so much for explaining and going over that. I find it interesting that you see this jump, and I'm always wondering different things. So I wonder if actually when the citation and the decision maybe came about, probably those were written quite a while before that happened, right? So I'm imagining the factum was written probably even a year before actually a decision came about. I'm curious to understand as well as far as what the tools goes, and I really appreciate you mentioning this specifically, that the database mentions the court citations where judges actually noticed and flagged them, but then there could be things slipping under the radar. So what's really happening behind the scenes with all of these fake cases?
So you're right in that there is a delay factor, right? Because sometimes you would write a factum or any submissions, and that gets submitted, and of course decision isn't released a while later. So even though these decisions are coming out in 2025 and 2026, we are probably looking at the submissions that were happening 6 months to a year ago. And so then the next question is it going to get worse or is it going to get better? And that's what we're trying to figure out, whether or not, because the tools themselves are getting better, that we hope to see that this trend decreasing, although from what we've observed, there's just more and more decisions coming out. And also, because of the way that we're conducting our research, which primarily relies on reported decision, as a lawyer myself, I know often decisions are not reported or published or made their way to Canley. So we might just be looking at the tip of the iceberg here.
Very, very interesting. Well, thank you for sharing those details. So specifically speaking on legal citations, and I think this might be important even for people who are outside of Canada. I understand that our Canadian legal citations, well, maybe in the US to some extent, but they follow a very strict, predictable format. So you've shown that makes sense and makes it easy for AI to kind of mimic that structure, right? So why does that structure sometimes will trick people or catch lawyers off guard?
Yeah, so that's a great question. I think for the folks who may not be as familiar with the Canadian system as you are, we obviously, like the other common law jurisdictions, rely on cases as precedent. So if a judge has decided a case in a certain way and you have a similar case coming up next, you would want to cite the results or the law as it was interpreted in the prior case to support your argument. Now, Canadian case citations all tend to follow what's called a neutral citation pattern, which is party V versus party B, comma, the year, the court abbreviation, and then a naturally increasing integer. So a case could be, Tom v. Jerry 2021 ONSC 1234. So just by that, it is two parties, Tom and Jerry, and the case in whatever the year, and ONSC stands for Ontario Superior Court. This system makes it easy for an AI to mimic. And so what I mean by that is we tend to use sort of moral terms to describe, lying or making things up. AI, as many of us know, it predicts what's the most likely answer based on the prompts that you give. So let's use an example. If you ask an AI, what is the most important case in Ontario that talks about spousal support in the context of family law? You ask that question. If the AI does not have access to a database, it's going to try to figure out what is the most likely answer to that based on patterns. So it's a family case, right? And so in Canada, the most common last name is Smith. So Smith v. Smith is the most likely answer. For an Ontario case, the chances are it's going to be out of the Superior Court, so ONSC is the court abbreviation. So Smith v. Smith, 2017, ONSC 135. Then that's how the AI would produce a case that really looks real, but isn't, because it is predicting the most likely outcome based on the prompts that you give. And the second part of your question is, why does this structure trick people, and why does it catch so many junior lawyers off guard? Is when I used to practice, it was important to cite as many cases as possible to support your argument, have a legal position, and then in your footnote, you might have 5 or 6 different cases. So, the Ontario courts have always ruled in this way, C, for example, case 1, 2, 3, 4, 5, 6, 7. There was a time where you could trust that those cases are real. Now, they may not actually stand for the arguments the other side claims that they stand for, but you can trust that these cases actually exist. That's no longer the case anymore, because even though it will look real, and it can even trick lawyers because of the fact that it follows a neutral citation pattern, they could be actual cases. And one way I can demonstrate it is that I'm going to, show my screen just for a little bit to see what some of these fictitious citations look like. So you see here, I'm going to zoom in just a little bit. This is on courtready.ca, where you can see this fictitious citations in Canadian courts. So what we have on the left-hand side, actually, let's do this quiz. Which one of these is a fake citation? Which one, Claudio, you pick?
Well, I would say the one that repeats the same last name twice, just for that case, but maybe the lack of the period after V makes me doubt my own. So let's go with Piper v. Piper.
Okay, Piper v. Piper was a real case, and Brown v. Swanson is a fake case, right? And again, to me, like if I didn't know British Columbia, so BCSC is the Supreme Court of British Columbia out in the western part of Canada. Unless I check, I would have not known that one of them is fake. So let's do one more round. Which one of these is a fake citation? Claudio, your turn.
Let's go with Wallace v. Crates Marine Sales.
Okay. Alrighty, they're both fake, right? So this is, again, like they both look very real, and I'm pretty sure there's like a similar case that's about a Valgartson. All right, so the final round. Let's see, you pick.
Yeah, I mean, it's just a fun guessing game here, but let's go with Alessandro v. Briggs.
Okay, so they're both real, right? And those were actually 2 of my cases that I did when I used to practice. So this goes to show that you can't really tell. If lawyers can't tell, then self-represented litigants who may not even know about how cases work or how case citations work in Canada, they won't be able to tell. Judges and clerks, again, they're so busy already, and they rely on lawyers or self-reps providing cases that are real, and we almost take it for granted. Like, frankly speaking, based on this research, this wasn't an issue before 2024.
No, very interesting. I also see, and I think all of the legal community to some extent have been following the different, decisions about that. A lot of them, end up making it to the headlines. It seems like in the beginning, in a few different jurisdictions, courts were kind of giving a warning at first. And then now we have documented consequences, whether that be, costs, whether that be the case gets referred to the regulator. So for lawyers watching these unfold, what are some of these, maybe let's call them unwritten rules, since I guess we haven't codified anything like that judges are following when they see AI misuse. I think there's a possibility of using some kind of precedent saying that you're maybe misguiding the courts or your other person. But I'm curious, how this risk landscape changes in the profession when we see this new phenomena happening.
Well, the risk landscape changes dramatically because the courts and tribunals are getting pretty fed up. Right? And you are very much accurate in that in the beginning stages, the courts were almost, well, they're not almost, they are giving benefit of the doubt that those who are providing these citations do so in good faith and they're not misleading the court. And secondly, what I think was happening at the time is that many people didn't even know that these are AI generated citations. So I'm just going to pause there for 1 second to discuss this. Is that in our research, we found cases, which we didn't put in the database, that in my own experience, I could tell that the cases were either hallucinated by AI, or had AI's hand in drafting. But while those citations were picked up by the judge or the tribunal member, the judge and tribunal didn't really go the full way by saying you use AI or got into the weeds on how and why these cases came into your submissions to begin with. So we are still seeing some instances where the judge doesn't really know or didn't really identify this being an AI related issue. But to your point about sanctions, well, we have separately published a database of sanctions, and this is to show how the courts have reacted to this issue. And so I'm going to share my screen again. This is also part of our courtready.ca's database, is on our homepage, is like how Canadian courts and tribunals are responding to AI hallucinated case law and AI misuse. So I'll give you some of the top line data, right? So in this case, we have about 42 plus 170, 147 total decisions that include some of the AI misuse from our separate database. And sometimes, the different parties appear multiple times. We group them into one just not to inflate the numbers artificially. So the 147 decisions where the court had an opportunity to sanction, 31%, no recorded sanctions. The court just said, okay, I recognize that you've had fictitious citations in your submissions. I'm not going to consider them, right? 49% warnings. So the warnings will look like, hey, look, you're doing this. You have to look at our practice direction and you cannot do it again, kind of thing, or threatening of further sanctions if the issue repeats itself. 20%, so 30 cases, serious sanctions. So when I say serious, they include imposing costs, regulatory referrals, contempt of court. Or this is another interesting one where if you're the successful party, you're normally entitled to costs, so other side paying your legal fees. But the court said no, because you used AI and you mislead the court in some way. So we see that as well. And when you look at trends, right? So this is the second graph. Okay, so you look at, first of all, an increase in the number of decisions dealing with this issue, right? So we had, from 1 in the first quarter of 2024, and let's see, this is almost 50 in the first quarter of 2026. And you see how you're seeing more serious sanctions and you're seeing more warnings. And what's also interesting about the breakdown is that as expected, right, as a proportion of the total number of sanctions, those with represented parties, legals, lawyers, and paralegals, tend to have a higher percentage of serious sanctions. 46% of represented parties have serious sanctions, where that proportion is only 15%. And that makes sense. Self-represented individuals, they're not represented. Courts tend to expect more from represented parties. So if you look at what kinds of decision, right? So here we have a tabulation of costs. So thus far, the courts have ordered at least $30,000 Canadian of sanctions for improper AI use. And so if you look at the serious sanctions going down here, the most significant example came out of Alberta, $17,550, and then next in Quebec, $5,000. Right, so you can have a a breakdown of the costs here as well. So all this is to say is that courts are more willing to impose serious sanctions in this issue. And of course, judges have discretion in this regard. So we haven't seen sort of a nationwide standard in the penalties that courts tend to give. But the ultimate message to lawyers and self-represented folks is that even by looking at the judicial language from 2024 to now, you can tell that the courts are in general annoyed and exhausted by dealing with this issue, because they also have to spend time and their own resources trying to find cases that they can't find anywhere. And we see this happening. Some of the decisions where the judge said, we're not supposed to be doing this, going to the judicial library to look for cases that frankly don't exist.
Right. No, amazing. Thank you for sharing that. And I understand that somewhat recently there was a US decision regarding privilege and generative AI, especially when it comes to having information in one of these, as you said, like publicly available, like free tools, right? So
Yeah.
as far as I know, there's not such an official recognition in Canada about privilege and AI, or like the kind of tool you're using. But I'm curious, overall in this situation, I think one of the things you showed is that over 80% of the affected decisions do involve self-represented parties, and they're turning to AI because it's often, affordable. We talked about, the language and just how popular all of the AI tools have become. Maybe what's the system getting wrong about this gap? Are there mistakes, in your personal opinion, what are some of the mistakes maybe that courts are making by simply because the technology hasn't been explained properly?
Right. And the explanation part requires those in courts and tribunals to provide this judicial education to self-represented litigants, because this part is important. Is not that self-represented folks are more reckless. Is not that they're more willing to lie or misrepresent the law. It's because in most cases, they don't have the means to afford a lawyer, or it doesn't make sense to, because you have a lot of these tribunals where the issue in dispute is, $4,000. So they can only rely, well, not can only, but they use a tool that is free to help them, and the tool sounds confident. It would be helpful if the courts and tribunals would do more to educate the folks who are coming in and say, look, if you rely on AI to draft and research, this is the consequence, and this is the issue, because no one wants to lose in a court battle. So if an AI is giving you law that doesn't exist, the chances are you will have less of an opportunity to win the argument. And this is where the gap is. First is on judicial education for the parties. And second, there ought to be a very quick and easy way to verify if the cases you cite are real. And that's what caused us to build CaseCheck, which is a semi-automated citation checking tool where you run your argument, you run your submissions through the tool once. So at least you know that once it makes it to the courts, your cases are authentic. And more importantly, we don't want fake cases to become real law in Canada.
Amazing. No, thank you for sharing that. I'm curious here, if through this entire conversation, you mentioned in the beginning right away that there was this situation that really wasn't a problem, right? You could rely on somebody else's memo and all of that. So if we were to hypothesize here, if a junior associate receives a memo full of AI generated content, they have this risk of fabricated case law, right? Or even if it's, in a precedent that didn't get caught in time. And what exact question should they ask to be protecting themselves, and what are some of the verification steps that could be helping to make sure that this never happens again? I think that most of us will probably always take a look at Canly if these cases actually exist, but I think there's something that you mentioned that is interesting, that it's not only about the citation itself, but also the context, right? Because sometimes it will be quoting a case where that is not the case at all. So can you tell us a little more about that?
Yeah, that's right. So what we're also now seeing is that is not just the fact that AI tools are hallucinated cases that don't exist. They're making up quotes from cases that do exist. That's one example. So when a junior associate receives any sort of legal position or legal submissions from anyone, I think the responsibility is on them to check and check thoroughly, because there's no way to tell just by looking at it that this is real or not. And that's the scary part. When the first iteration of these tools came up, it was kind of easy for someone with a legal education to tell. So for example, I know that the Ontario Superior Court doesn't handle, 100,000 decisions a year. So if a decision has the neutral citation number of 2021 OMSC 123456, then obviously I know that cannot be real. But that's no longer the case. These tools are getting better at what I call mimicking reality. So the only solution for the lawyers is to check. And again, there's also this regulatory concern, right? So what we see is that courts and tribunals are asking people to verify or certify that every authority is real. So right now, as we see in the system, it relies on the person submitting the legal submissions that the cases you submit are real and they stand for what you claim they stand for. And that responsibility is mostly going to fall on the junior associates, the clerks, and the assistants. Is about who's the last person verifying everything. And if you're the last person doing it, it's on you to get it right.
Yeah, thank you for bringing that up. I think to go to the end of our conversation today, I wanted to ask you specifically about the tool that you've built that have this idea of helping to catch these hallucinated citations before they reach the courtroom. Looking at everything you found, what is maybe the single most important part of our relationship with legal tech that you want people to see?
That folks who are using any kind of tools have to be a bit more skeptical with the information it is producing, right? And especially when it comes to legal research. Now, there are some wonderful tools out there that do have access to a database of law. Those ones, because they're connected with a database, they can actually go and fetch the information and give it back to you. But to date, the publicly available tools that people use that I see appear in courts, and sometimes they mention the name of a specific tool, they don't have access to county. So how are they getting the information? And I don't think a lot of folks, self-represented litigants know that. They have to be more skeptical because ultimately they're going to be penalized by the courts, not the tools that they use. Now, of course, we can have a whole separate conversation on the extent to which these tools ought to be held responsible for confidently producing things that are wrong. But for now, it is the person using it who bears the ultimate responsibility and burden when it comes to using it for court/legal purposes.
Fantastic. Well, thank you, Tom, so much for coming on the podcast and sharing these details. As for people who are interested maybe in finding the tool and reading more about the research, can you just share with us so we can be easily found in the video? I'll make sure it's also in our show notes.
That's right. So yeah, thank you for that. So all of the research there and the tools are on our website, courtready.ca, and is right on our homepage. So if you go here now, you can see the research for both the sanctions and the fictitious citations and case check as well. And of course, we have our other tools that helps folks navigate the legal system.
Fantastic. Thank you once again. And thank you all for tuning into today's episode.
Thank you. And have a great day ahead.